Hey, everybody. I hope we have a lot of people here. I'm going to be talking about Darrell Brooks, especially the judge, and how she handled the whole Darrell Brooks trial. And we're going to do a little bit more fundraising for Kyle Rittenhouse's family's situation. They need some money here by Friday, essentially. They're being evicted. So I'll interrupt the proceedings at some point down the line. And I think that Faith and maybe the others are going to be joining on a little bit later tonight. So if you want to hear from Faith and Wendy or Mackenzie, you might want to stick around. But at any rate, let's talk about Jennifer Dorow, the judge for the Darrell Brooks case. And a lot of people have been really, let's say, praising her for her patience and a lot of things. I mean, she handled the Darrell Brooks trial, in my opinion, very well at times, and at times, maybe not so well. But then again, keep in mind, I'm not a lawyer. This is strictly Monday morning quarterbacking. Okay. And a lot of people say, well, how dare you judge how a judge performs? But, I mean, we watch football, we watch a quarterback, and we can say, yeah, that wasn't a very good pass, and he's not having a good game today. We can do the same thing with judges. Everybody has to understand, though, that our, layman's interpretation of what's going on could be mistaken. All right. And so, with that in mind, and by the way, I'm not going to be giving out any legal advice. I'm not going to be telling people how to handle their own legal affairs. Just all we're going to do is just look at what Judge Jennifer Dorow does during the trial and decide, well, could she have done something differently, and would it have helped? Okay, let me go ahead and open up the chat. Let's see here. All right, Lucifer's in. Oh, she's very cute. You're talking about Judge Dorow? Yeah, yeah. That raven hair, man, that just does it for me. Um, yeah, armchair quarterbacking, Sunday morning quarterbacking, no, Monday morning quarterbacking. Yep. Okay, so we have a whole bunch of little snippets of the trial, and this took forever. I started out this morning putting together the list, and I have probably 20 or so URLs here. And of course, each clip is only maybe a few seconds long, maybe 10, 20 seconds long. So this might take a long time tonight. I don't know. This will be the first time. And I know that I'm not going to hit all of them. I mean, everybody who has watched the Darrell Brooks trial has their favorite moments, right? I'm not going to be able to capture all of them. There are some crazy things that happened. Uh, and keep in mind, I'm picking these events mostly on how Judge Dorow handled it. This is not a crazy moments of the Darrell Brooks trial video, or Darrell Brooks goes bonkers video. This is about how the judge handled things. All right. So let's go ahead and get her started here. Give me 1 second. And by the way, the transition between video is going to be a little slow because I wasn't able to open up all the tabs. I'm actually copying and pasting into um, another window, so there's going to be a little bit of delay in that. So give me 1 second. Okay, so let's go ahead and transform over here to the first one. Let's see here. Oops, that's not it. This will go a little bit smoother from this point on after we get done with the first one. All right, here we go.
Brooks, you just interrupted me within a minute of us starting.
Oh, I forgot. I have to turn down the speed a little. I think I'll go with 125. Um, let me back up a little bit here. And let me know. Oh man, somebody says I wouldn't give them a dime, let them get evicted. Gee, that's kind of mean. I don't understand why somebody would write something like that. I mean, that makes no sense. I mean, what the hell? But whatever. Everybody has their own opinions. Here we go.
Reserve my rights if I may.
Mr. Brooks, you just interrupted me within a minute of us starting this case here today. I'm asking you to respectfully not interrupt me. That's the second time, so I can go through the list of things that I need to get through this morning.
I just wanted it stated for the record.
Mr. Brooks, it wasn't the proper time to do that. That's now the third interruption. So,
With all due respect, Your Honor,
Mr. Brooks, by saying all due respect doesn't change the fact that you're interrupting me. Your objection is noted, all right? But you need to stop interrupting me so I can get through what needs to be done. I have a number of documents that I need to discuss this morning. Mr. Brooks, you do not have a right to interrupt the court. I will remind you once again of the Supreme Court rule. It's on a yellow laminated, double-sided piece of paper that is before you. I checked, I verified, it is.
I accepted and returned
Mr. Brooks, that's yet another interruption. Let me get through this, please.
I just want.
Okay, here we go. So she has the court rules laminated for him, and she's going to hand it to him. Darrell's not going to care about that. Now, keep in mind, she's playing mommy here. If you'll notice, Darrell Brooks is the petulant child, and the judge is playing mom. So you keep interrupting me. That's the third time that you've interrupted me. That's the fourth time. And here's the problem with that. And this is my opinions, okay? You might disagree. And I would love, by the way, I've got the chat open. I'd love to hear what you have to say. But in my opinion, you're playing Darrell Brooks's game. He's a toddler, and this is probably how he was raised. And one of the reasons why he's in the shape he's in. It's because, he likes this back and forth. He likes to interrupt and he likes to be scolded. And so she should have recognized this early on. And I think after a while, she started catching on to it. But you don't want to get into this kind of exchange with people. All right. So on this take here, I don't think that she's handling him very well. Now, she will get better. All right. And keep in mind, and I want to put something out here before I start getting a lot of hate talk here. I admire Jennifer Dorow's patience and her knowledge of the law. There's nothing wrong with her knowledge of the law. In fact, and maybe this is a criticism of Judge Dorow, but she plays everything by the book. You could, if you're training future judges, you could actually put the videotapes of her and how she handles each one in a training, right? So when a defendant does this, here is how you handle it. The problem is that this is probably the one case where she needed to throw that training manual out because she's dealing with somebody who's going to make it very difficult. He's going to take advantage of her verbose responses and her patience and her careful crafting of prose and to basically delay the proceedings and drive her nuts. You can tell in here that she's already starting to come a little bit uncorked. All right. Here we go. Let's see. Overall, this judge erred on the side of tolerating him in order to prevent any possibility of her being criticized for having any kind of bias. There is that. However, you don't have to be, super forgiving to be, like considered to be unbiased at all. She could have planted this thing down much firmer and people still would have said it was a fair trial. So I get that. She doesn't want this to go to to the appeals court and get overturned. But in my opinion, she ran the court proceedings as if she was terrified of an appeal overturning. And I don't think you can do that. All right, let's see here. Salvador. All right. Hey, how you doing there? Salvador Dali, if you want to put in the URL of your own channel, Salvador Dali does, and this, no, it's not the painter, okay? He does his own streams where he focuses on trials, and I don't recall which one he's doing right now, But if you're interested in trials, the kind of the juicier ones, kind of like the Darrell Brooks thing, he has a very good channel, and he's probably always could use more subscribers. So if you want to put the name of your channel into the chat, maybe you can get some followers. Okay. She didn't want to be accused of racism. Yeah, I don't think that that would have been an issue. Yeah, she knows the case is open and shut. Guilty verdict is guaranteed. Okay, I'm glad you brought that up because that raises a question. Why not just give him everything? Why not just go ahead and, play along with his games and stuff? And in the end, you have to understand that he's going to end up running the courtroom if you allow that to happen. Now, the guilty verdict is down the road. She knows that. Here's my opinion on this. This thing is being televised nationally. It's got a huge following. There's a certain decorum that has to be met. There's a certain respect for courtroom procedures and the judge. And I'm afraid that if you allow the defendant to take control of the proceedings, you undermine the sanctity of the courthouse, of the courtroom. And so there is a certain, let's say, PR value in running things very tight and informing the audience and everybody out throughout the nation that when you go to trial, you don't mess with the judge. And I'm afraid that watching Darrell Brooks, a lot of people can go in thinking that they can roll the judge like he did. And that's really not a good thing. Okay, so the judge commands respect, is in control, and I really think that Judge Dorow needed to do a better job of making sure that everybody saw that. Now, she does some really good things here too. Okay, and in terms of her knowledge of courtroom procedures, she's top notch, very smart. Okay, she actually ran for the Supreme Court of Wisconsin and didn't win, and I think that's unfortunate because I think she'd be a great Supreme Court justice. Probably too conservative. She is pretty much hangs out there on the right side of the political spectrum. Yeah, her being too lenient might set a precedent. Yeah, that's what I'm kind of talking about. And again, upcoming new judges might start to think that that's how you handle these situations. Okay, let's go on to the next one.
Viewing. Again, arrangements have been made for you to appear in street clothes or civilian clothes. I would like you to appear in street clothes, and the reason why, sir, is to reduce or even eliminate even the appearance that you are in custody. And it is your choice, though. Are you willing to go back to your cell and put on your suit?
It is my right to do so or to not do so. And at this point, Your Honor, who doesn't know that I'm in custody?
Mr. Brooks, I've had many trials with individuals who were in custody, and when I've talked to the jurors after the conclusion of the case, they had no idea. The whole point of allowing for street clothing is not only to shield jurors from the fact that you are in custody, but also you being in a suit and a tie or other street clothing, I think also lends to the dignity of the proceedings. This is a trial. Again, it is your choice. Are you willing to go back to your cell and be dressed in the street clothes that you previously appeared in?
With all due respect.
Right now.
Okay, well, I forgot to turn on my ad blocker, but whatever the case, here is a problem here. He is the master deflector. Oh my God, he's good at it. You think that you can pin him down to a yes or no, and he will worm out of that every time. And she asked, are you willing to go? I think the better question would be, do you want to be in street clothes or do you want to be in that jailhouse uniform? Make your choice. I really don't care. Well, you really do want to convey the idea that the judge, the court would rather have the person in in a business suit. And that's okay. I mean, you can say that, but at the same time, are you willing to go? He's the kind of person who would say no to any question if you ask, are you willing to? It doesn't matter. That's almost a trigger with these people. He's like a toddler. And so you have to treat him like that. Frankly, you know, if I was the judge here, I would have just told him, look, when we get done in recess, I'm going to have the bailiff take you back to the jail or take you back to where the suit is. You can put it on or not. I really don't care. Frankly, I prefer that you be in a suit, but whatever you're wearing when you come back, that's what you're going to be in, and just be done with it. Rather than go through this, do you want to? Are you willing? Because he's just going to deflect all day long. That's just Darrell Brooks for you. All right, let's see what we kind of we have some. Where in Illinois versus Allen does it say that he can be present from another courtroom? Okay, I don't know if you meant this sarcastically or not, but in Illinois versus Allen, it does say that the judge has discretion to come up with alternative methods, and she took advantage of that. Okay, and I think I actually have a clip that's going to show up here where that's going to be an issue. So you might be getting a little ahead of me there, but Illinois versus Allen does allow her. It doesn't prevent her from just taking him and putting him into another room altogether. He can hear the proceedings. He can object. There's nothing that say that he has to be in the actual physical building. Okay, let's go on to the next one. And yeah, he did run that one ragged.
So while we're on the record, may I challenge the subject matter jurisdiction?
No, you may not, sir. You need to file a motion in order to do that.
So
Mr.
the
Brooks?
motions I filed haven't even been responded to. I gave.
Mr. Brooks, you're interrupting me
No,
yet
you
again.
just weren't speaking,
All right,
so I didn't
Mr.
interrupt.
Brooks, you are now going to be removed to the
I
other
don't
courtroom.
consent to that.
I have
I am
had
under
a
duress.
dozen or
I have
more
it.
interruptions.
I
You'll
have
be
shock-
off the record while we
shocks
do
on my
that.
ankle.
Thank you,
I don't
everyone.
agree to a stop. I move for a motion to dismiss for being under duress and being coerced.
All right, I'm going to give her the props on this one. Notice how she handled it. You know what? You're being removed, and she gets the hell out of there. She learned early on that hanging around, she's going to fend off questions. One of the problems that Judge Dorow has is she feels compelled to respond to every one of his comments. And he recognizes that. And so he's going to pop question after question after her, make one statement after one other statement, because he knows that she feels compelled to respond to it. Here, she just gets out of the room. Smart move. She should have done this actually more often. Do not send any hot meals to Gaza. Okay. You heard Graham. If you were thinking about sending hot meals to Gaza, well, don't. I mean, just get that, don't even think about that. I'm not sure what that's about. You should probably do some research on that charity before donating. I have no idea, Graham. But have you been drinking tonight? I don't quite get where you're coming from tonight. You usually you're so on point with everything. And by the way, Graham is like almost always the first to respond to any video that I post up. To the point where I kind of wonder if that's not his life mission. Oh, in the ad earlier? Okay. Yeah. I didn't even follow what the ad was about. Okay. Here we go. Oops. Hang on.
Before I turn to you, Attorney Opper, because I'm not sure if Mr. Brooks heard this or not, at the very end, before I removed him, I wanted to make sure that the record is very clear. I will note a continuing objection to the issues he raises regarding his name and other things. He's There are filings that substantiate that. It will be my position it's not needed for him to do that every single day because I've noted a continuing objection. With that, you wanted to make an additional record?
Yes, Your Honor, it's probably appropriate at this stage. I did want to address a topic that's maybe not been raised in the courtroom, but has been raised in the public, and it seems to kind of go hand in hand with the events of this morning, and that is the mental competency of Mr. Darrell Brooks.
Okay, so I played this a little bit too long. So he's taking off his shirt and he's ranting. She muted him, and she muted him, quite a bit during the trial. In reality, that's about all she could do. I thought that she could hit the mute button a little bit earlier on sometimes, but in all honesty, I kind of forgot what my point was on that particular clip. So we'll move on to the next one, because I'm thinking halfway through and thinking, like, what was this important about? I forget. But I think it was one where I was praising her handling of this situation, but I just can't remember what my point was. I promise not to have that problem too much tonight. Whoops, wait. Oh, okay. Never mind. Hang on.
There's going to be a lot.
Modern food science has literally created thousands of artificial chemical ingredients that never existed.
Good. I like
are
them.
going to be shown. Why not keep everything public the way that it's intended to be? And because of the fact that you've already ruled on it.
Now, he's a little hard to hear here, but he's making some arguments as to why the trial should be public, televised.
Made that on the record.
Oh, I'm sorry. No, it was as to whether the witnesses should be on camera.
Let's keep it the way it is.
All right, thank you, Mr. Brooks. I appreciate your legal analysis of that and your factual analysis of the prior ruling that this court gave. I thought you did an excellent job making some very good points, many of which I relied upon previously. There is a mechanism in the law for a party to bring a motion for reconsideration.
Yeah, I don't know what that is. Okay, so she's complimenting him. And I remember watching this on the live stream, and people were in there going, well, I don't understand why she's saying good things about him. She is basically getting prepared for an appeals where he's going to claim that he needed legal representation after all. If you remember, he wanted to represent himself, and part of the questioning was, is he competent to do that? And so she's going to compliment him throughout this trial by talking about how those were really good arguments you made. That was very intellectual. That was a sophisticated argument you just made. She's going to do that all the time to reinforce the idea that he was of sound mind and body enough to represent himself so that he couldn't get this thing overturned later. Now, I'm glad also that it was brought up here, because another thing that she does, and that is, you'll notice that she explains everything. This is rare among judges. I've watched a lot of trials, and for the most part, if there is a courtroom procedure and they dial it up, they're not going to explain verbosely about why they're doing it. All right. And you'll see this all the time from her. Almost every time she talks, she is explaining out exactly why she's doing it. Talking about Illinois versus Allen and all that kind of stuff. And you may be wondering, why is she doing that? Well, believe it or not, I don't think it's to prevent an appeals problem. I think she knows that this is going to be appealed, and she wants to lay this thing down verbally, because that makes it a lot easier for her to write any kind of response to an appeals brief. So if Darrell Brooks does appeal and they say, well, okay, here's his appeal, what do you have to say? Everything that she has done is on record already. It's all verbalized. So she doesn't have to sit there and write out a lengthy response. She can just simply say, it's all on record. Now, maybe she might still have to type up something, but she can take it directly from the transcripts. So it's really smart. It makes the trial longer, but it makes her job a lot easier when responding to appeals. Now, I could have this all wrong. And if you're a lawyer out there, you might say, "Oh, that's not it at all. What the hell is Johnny Walker Dredd talking about?" In that case, by all means, in the chat, tell me if I'm wrong, but it sure seems like that's what she's doing here. And if so, that's pretty smart. Although it does make listening to the trial very annoying, because I really got tired of hearing about Illinois versus Allen. You know, every time she threw him into the old penalty box, because he would act up, she had to sit there and talk about Illinois versus Allen. And she doesn't have to do that. I mean, a lot of judges would say, "You know what? I've had enough of your ass. Bailiff, go take him into the other room. I'm sick of him." Now, you wouldn't do that in front of a jury. But if the jury's not in there, you'd say, "Just get him out of here. I'm sick of it." But instead, she's going to say, "Pursuant to Illinois versus Allen." Well, guess what? The transcript is going to have all that in there. And if it gets appealed, she just simply shovel that off. It's pretty smart. I have never seen this done before. Maybe it's really common, though. Like I say, I'm not a judge or an attorney.
Nothing else on my list, but we want to give Mr. Brooks one more opportunity to change out of his orange jail uniform. Excuse me.
That I would give him an opportunity to do. Mr. Brooks, would you like to go back and change into your suit?
My position has not changed whatsoever, and it will not change, as it is my right to come into court how I would like to. Just like I should be awarded.
Notice the deflection. Would you like to change? It's my right to wear whatever I want. Well, yeah. So we're asking you, do you want to change? He's not going to answer yes or no.
The right to be present for every proceedings in this trial.
All right, I'm muting him again. I note your objection. I will take that as a clear indication you do not want to go back to the jail to change into street or civilian clothing, that you are exercising your right to dress in the jail attire.
Okay, a couple things. Notice again, she has to explain it all out, right? Also, she muted him and said, "Oh, okay, since you're not going to answer my question, it's a no." Okay, good move on her part. He wanted her, he really, really badly wanted to get into exchange with her on that. And he would have won. Because again, he's a toddler. He's really used to doing this. And again, I also want to make everybody understand that this is probably how he was raised. This is how he interacted with his own mother. I'm just not going to go along with anything. And you see how he worked out. So I'm glad that Jennifer is taking care of this one. All right, let's go on to the next one.
My plan, at least for the afternoon.
I would like to go back over there, Your Honor.
You would like to, you're asking that to voluntarily be taken to that courtroom.
I'm trying to seek to understand how the testimony evidence that was given could be
Mr.
considered
Brooks, I've already
evidence.
dealt with that. I'm not going to deal with it. If you want.
Notice the deflection. She asked, "Do you want to go to the other courtroom?" He comes up with something completely different.
I go to that courtroom. Are you waiving your right to be present right now?
Can I at least raise the issue of subject matter jurisdiction?
No, there's no lawful motion before the court. You may not.
Are you making a judicial determination that I cannot?
Mr. Brooks, I'm going to bring the jury out. I'd like you to stay. That's my preference that you stay. You've certainly demonstrated throughout these proceedings that you have the capacity to follow the rules, that you have the intellect to make cogent, coherent, articulate, responsive arguments when you so choose. But when you start doing what you're starting to do right now, going back to filings I've already addressed, and start talking about subject matter jurisdiction, that is a tactic by you that I believe is to disrupt and to delay the proceedings.
And it's working. She even said, "This is a tactic by you to delay the proceedings." Yeah, and you're playing right into it by going back and crying about it. This is nagging almost, right? And so he got what he wanted there. And keep in mind, there's some good things here. Again, she explains out again why she's doing what she's doing. Um, Here's my beef with Judge Dorow on this. If I'm the judge, you go where I tell you to go. There's none of this, like, would you like to hear their crap? Um, he doesn't have control over that. Take control of the process. If you're sick and tired of him, send him to the other room. If he's wanting to go to the other room, no, you're going to stay the hell there. Now, you piss me off enough, and I will send you there. But there's none of this. I would like to go to the other room. I don't give a damn what you want. And I think that would have set a better tone. And keep in mind, you can't do that in front of the jury. Okay. But I think that she could have done that in this situation here. Take control of the situation. Tell him where he needs to be. By the way, it's gone awfully quiet in the old chat. What happened? Nobody interested? Is there anybody even? I can't tell how many people are in, but okay.
I know you're making an error, Your Honor.
Mr. Brooks, I'm not going to have a debate with you right now. We are continuing on.
Want to bet?
I'm giving you the courtesy to respond to each one of these things. That's how I've responded. I expect that you will, even if you disagree with my decision, sir, that you will respect it and we'll move forward. The next piece of paper filed at 1:52 p.m. says, are you making a judicial determination? I'm not allowing my right under the First Amendment to freedom of speech in this courtroom. Mr. Brooks, we have rules of decorum and courtesy. They have been provided to you multiple times.
To break. He doesn't care about rules of decorum. And in fact, if you explain to him what those rules are, that just tells him what rules he can break. Here's a mistake that she made. I could not find the actual video of it, but I've seen it. It was on early on. And she told the courtroom that she was not going to hold Darrell Brooks in contempt. Why? Well, if you hold him in contempt, you have to have a hearing for him, and that delays the procedure. And therefore, she told everybody she's going to avoid holding him in contempt. He heard that and thought, hey, if I can get a contempt, well, that delays the procedure. That's exactly what he wants. So that just encouraged him to act like a jackass throughout the entire trial. And so you'll hear him say, are you holding me in contempt? He pesters her about it. Why was he so insistent on it? Because of that. He knew that he would get a hearing if she held him in contempt, and she's trying her best not to do that. It was really funny to watch that unfold. What exactly is a judicial determination? How is it different from a non-judicial determination? I think a judicial determination is a decision made by the judge that's on the record. I'm guessing. I'm not a judge, not a lawyer, but I think that's what it would be. And almost everything that she does is going to be a judicial determination. He picked this thing up from some sovereign citizen website, and it's just a series of questions designed to befuddle a judge, make them angry, essentially. And I don't know where he got them up from. I think that his mother may have downloaded some of these questions off the web and got those to him in his jail cell. So he studied the script, and he's trying it. And I will give this up to him. Okay. I hate to compliment him on anything, but he's rather eloquent. I know you're thinking, what? Darrell Brooks, eloquent? Notice he doesn't stammer much. Notice that he rolls this stuff off his tongue very easily. It's like he's been rehearsing this for the last 6 months. He hasn't. He probably printed these things out just a few days ago. Remember, he threw his lawyers out just only a matter of a week before. So he's really quite good at just spewing this sovereign citizen nonsense. You see them on YouTube all the time, and they get all tripped up, and they start doing the ums and the ahs and stuff like that. He doesn't have that much trouble with it. It's quite impressive in a way. If only he could spew out sensible things, that would really be a lot better. Let's see if there's anything else on this.
They are part of the materials that you have before you.
Do they fall under the First Amendment?
SCR Chapter 62 discusses just the standards of courtesy and decorum for the courts of Wisconsin. In addition, sir, parties are able to file requests with the court.
He's not listening to a thing she says. He's not. Well, there's another thing about sovereign citizens you have to understand. And by the way, I say you have to understand, not trying to talk down to you. Okay, that's just sometimes that's just the way I talk. But I'll go along with that anyway. One of the things that one of their big problems is that when you're trying to talk to them, they're not listening to what you have to say. They're thinking about what they're going to say as soon as they get the opportunity to do so. And that's what he's doing here. In his mind, he's thinking of the next thing to say when she shuts up. And if she doesn't shut up, he'll just interrupt her. The other thing is, and I forgot to mention this at the start, he is in custody. He's facing life sentences. There's really nothing she can do to punish him. Another reason why she doesn't want to do the contempt of court thing, right? What are you going to do? Sentence him to 24 hours in jail? He's going to serve 1,000 years, and he kind of knows that. So he has no fear of being held in contempt of court or being punished at all. And so she's in a very precarious spot here. She can't punish him. She's going up against a petulant child who has no respect for courtroom procedures at all. And in a way, she handles it pretty well. I just have some issues with some of the things that she does. And so we're going to go on to the next one. KTZ, it's been a while. I haven't seen you around, or maybe if you have, I just haven't spotted you. Okay.
From what you explained yesterday, the objections you said have to be like, I think you said like 3 words is the way to actually object. So I don't recall you
I can give you up to a sentence. What I am trying to avoid, sir, are what are called speaking objections. The idea behind that is that you give me just a little bit of information so that I can either make a determination or, if appropriate, send the jury back out so that I can then hear arguments from the parties. Some objections really are 1 word, hearsay, maybe 3 words, calls for speculation, things of that nature. So if you're willing to abide by that procedure, then you can.
Notice that she mentions a couple of types of objections. Hearsay, calls for speculation. He heard those, and he doesn't know how to object. He doesn't know anything about the law, and so he picked up on those 2, and he's going to use those things constantly. Relevancy, as he calls it, really relevance, is the 3rd one. And you'll notice that he probably lays down about 10,000 objections throughout the trial, and they're all from one of those 3 categories because that's the only objections he knows. And so she taught him a couple here. He doesn't know what hearsay means. He thinks hearsay means I disagree with what that person is saying. I don't think that person is right. And to him, that means hearsay. And of course, hearsay means that the person is basically presenting testimony from someone else. And he doesn't understand that. She tried to explain it to him, but he never got it. He never figured that out. And calls for speculation, he threw that out in the craziest ways. Did you see the car hitting the people? That calls for speculation. What? What's speculative about that? Oh, man. Yeah, he ends up using all the ones the prosecution uses. That's true, but I really, to be honest with you, um, hearsay, calls for speculation, and relevancy are the only three that he ever actually uses. I don't recall him using anything else. Okay, let's go ahead. Next one. Hey, if anybody can check my Oklahoma Texas softball score and post it in the chat, I'd appreciate it. I know that Oklahoma scored at least a couple of runs, but they're playing against
Do you
number
have
one
any other
team,
issues you?
so we'll see. Yeah, I almost put this one in there as an example, but he did say, "So are you going to overrule every objection?" There's a lot of good sarcastic responses to that. She handled it like the training manual would say to handle it, but somebody like that judge in the Theodore Edgecombe trial, I forget his name, Wajinski or whatever, he would have just absolutely stomped a mud hole on that one. Yeah, you keep asking stupid questions, and I will over. I mean, I don't know. I don't know how I would handle it, but yeah, he did that all the time. Okay, let's see here.
You want me to address?
Just very, very quick. I still don't understand the nature and cause of the charges against me, Your Honor, and I still would motion for, or tennis motion for the jurisdiction to be proven, the subject matter jurisdiction. And also a motion for finding a fact.
Your requests are all noted for the record, and for the reasons previously stated on this record, I'm not going to answer those requests any further. They've already been denied by the court. I'd point you to the case of, can I have my post-it note back? The Beneby decision at 654 F3rd 753.
Who in here thinks that he cares about the Benemy decision? He's not even listening.
All right. Anything else, sir?
I need to go back and play this again because I missed something.
That's been at least.
Or tennis motion. I still don't understand the nature and cause of the charges against me, Your Honor.
Okay, yeah. So this is classic sovereign citizen stuff here. I don't understand the nature and cause of the action. I don't care. You've been informed of them, and that's all I care about. Sovereign citizens think that the law is that you have to understand before you proceed. No, that's not what the law says. The law says you have to be informed of the nature and cause of the action. And as long as you use plain English, I mean, you can always ask the accused, do you understand? And if they say no, you can try to explain it to them again, in plainer language or whatever. As long as you put an effort in and everything you say is in plain language where a reasonable person would have understood it, that's all you have to do. And he thinks that he can derail the procedure by making this claim. And it got bizarre because at one point he figured that if he just doesn't understand anything, well, then you just can't go any further at all. So she would ask, like, well, do you understand that there are rules of courtroom procedure? No, I don't understand. It got wild, right? But again, he still thinks that that you can't convict him if he didn't understand what was going on. Simply not true. And a lot of people are in jail who didn't understand what happened to them. Okay, KTZ, the judge in this trial is why my show is called Overruled. She had to say it so much. What show are you talking about? I'm not aware of it, but if you want to put in the chat there, where people can watch it, put it in there. I'm more than happy to share the information. At any point, do any of his objections get sustained by the judge? Yes. He did catch the the prosecution a few times, where they had, well, let's face it, when you're facing a pro se, the prosecution feels that they can get away with a lot more. And there were some instances where leading, by the way, there's the other fourth one, leading the witness. So he did 4 objections. And he actually got a few leading objections sustained. And I think the prosecution was like surprised. Wait, I know it was a leading question, but he actually caught that. And again, the judge would say, sustained, good job. You really know what you're doing. You getting this down, clerk? Is the transcriptionist making sure that she's capturing my compliments to him in case he appeals this? Right? But yeah, he'd actually, he probably got about 1% of his objections sustained. I got a question mark from IT. I have no idea what that refers to. She stayed so calm and polite to him even when he was actively trying to cause a mistrial. I give her credit for that. Yes, that is probably her main claim to fame in this. Although you could see her slow burn a number of times, and there was a few times that if she had a rock or something, she might have thrown it at him because you could tell in her face that she was just fed up with him. However, she did maintain her composure throughout the entire time. She did show a lot of patience. And in the end, the trial did get done. He got convicted. She nailed him for 1,000 years. So the results are fine. So you can't complain too much at all. You should see the sentencing of George Reel. Oh, Borowski. Yeah, that's the guy from the Theodore Hitchcomb trial. Really late in the defendant. I would love to see that. If you can post the actual URL for that, then maybe we could show it tonight. But no, Borowski was an animal. But you know what? He led a very fair courtroom. You can't complain. He was rough, but everybody got their, the defense had their rights protected. The prosecution was given the opportunity to convict. He did his job. I just wouldn't want to be facing him at all. 50K to 1TX. I'm not sure what that means. Okay, don't know. Overruled is the deep dives into one case. My other show is Crime Land, where I cover a lot of small stories in one episode. Is this on YouTube? If it's on YouTube, if you want to post the URLs in the chat so people can watch it, great. Got no problem with that. Okay. Oh, I'm sorry. It's 5-1 Oklahoma over Texas. Okay. I thought it was 50K 1TX. I'm like, what? Okay, got it. Well, that's good. That's good. We'll see if that holds up. And thanks for the input. Oh, this poor girl. Oh man, she got ravaged by Darrell Brooks her entire life almost.
So, to the best of your recollection, you were not.
By the way, KTZ posted the URL, so if you're interested in that, by all means, go there. And hey, how about subscribing to KTZ? He's probably got a lot of great content. I'm not that familiar with this channel.
Not drinking both of those days that you cited, the 20th or the 21st.
The 21st. Hold on. Mr. Brooks, under 90611, I'm stopping this cross-examination. You've asked the same question, multiple questions, multiple times, and at this point, I'm going to declare that the opportunity to cross is now concluded.
I didn't know that was the same question, Your Honor.
Mr. Brooks, it's been asked and answered multiple times. So with that, I'm going to turn to the state to see if they have any redirect.
Some brief clarification.
Go ahead.
She just absolutely demolished him on this one. So Oh boy. You'll notice at the end there, she basically just turns to the prosecution and says, "Are you willing to go ahead and start?" And they said, "Yeah." They will jump in immediately just to shut him up. And it turns out that that was one of the effective things that she did, was to just simply turn to the prosecution and tell him, "Go." And he seemed to have a little bit of trouble, you know, with the prosecution at that point. He would argue with her all day long, but he seems to struggle against them. And I think that one of the reasons why is the attorney that's sitting really close to him. Um, I forget his first name, but he's a pretty good sized dude, and Darrell is a little tiny thing. And I think there might have been a little bit of you know you know a little bit of cowardice there on the part of Darrell Brooks. So I don't know. Let's go ahead and play a little bit more here.
Ms. Patterson, after the...
Oh no, that's not what I wanted. Got to get to the next one. By the way, you notice that she shut down the cross-examination. She got more comfortable with that as the trial proceeded. He would go into this, well, do you know the plaintiff? And she put up with it for a while, and then after a while she said, "Look, we're not doing that anymore." There was a whole bunch of stupid questions he would throw out, and we'll talk a little bit. I have a clip on that here, so we'll talk about that when it gets here.
Leeway to ask questions at this point under 90611. Move on.
Just so I'm clear, you have never had any interaction with the plaintiff.
Objection.
Sustained.
You've never seen the plaintiff.
Objection.
Sustained.
Never spoken to the plaintiff.
Objection.
Sustained.
Never seen. Do you see a plaintiff in court today?
Objection.
Sustained.
Do you know if there is a plaintiff in this matter?
Objection.
Sustained.
And here is where I don't like what she's doing. She should have shut this thing down immediately. She was really inconsistent with this. But after the first time that he did this to a witness, I would have told him, if I hear the word plaintiff out of you, this witness is coming off the stand. Now, I don't know if I can get away with that, but every question with plaintiff, there was an issue with it. And the biggest problem with it is that even if his claim is true, and that is that only a human being can, raise charges against somebody, the witnesses on the stand are not the people to ask about that. That's a legal question that has to be handled with the judge. The jury has no right to determine the law. They determine the facts and whether they match the law. But the law itself is to be determined by the judge. So this whole thing about whether the plaintiff, whether you can question the plaintiff, is not a question for the witnesses. But okay. So in this case, I really felt that she should have shut this thing down and she let it go on. And I know that it irritated the prosecution a lot to have to go through this. And by the way, it's nothing that would have worked in the appeals thing. I don't know why she allowed this to happen so often. Okay.
But I will make a record of the following.
Okay, let's see here. We got some. It's just KTZ on YouTube. I'm the only KTZ with subscribers, so it comes up first in a search. Okay, good deal. I'm glad she protected the witnesses from him, especially the ones who were victims. She did a good one time when he tried to badger a witness, and I couldn't find the clip, but she ripped him a new asshole. So that was good. Yeah, she was very protective of the witnesses.
Following, I have the result. I am going to scan it, have my clerk scan it. It will be filed as confidential, though. It won't be available to the public. but it's there for appellate purposes, but I can confirm that the test result for COVID-19 was negative. And again, I required the Sheriff's Department to provide that result to me, and it was, and it will remain under seal. I realize I'm disclosing that result, but I feel obligated to do that given the motion that was raised 2 days ago by Mr. Brooks. Again, By
the way, the whole COVID thing, I couldn't find the clip in time for the show, but when he was raising up the whole COVID deal, he thought he had COVID, and he was basically fighting the whole idea of having a quick test taken, is Comedy Central. One of the funniest things you will see in a trial. And don't watch his reaction. This is hilarious.
I do intend to take an early lunch. So that will hopefully give Mr. Brooks an opportunity, if he so chooses, to review the result himself. It was put in front of him. I did see that he either shoved it or tossed it or just dismissed it. It looked like it went on the floor when it was put in front of him, but we'll certainly have the deputies give that to him again. During the recess for lunch, Mr. Brooks will also be given the opportunity to change into street clothes if he so chooses. But when we come back, he will be in this courtroom. I agree. Mr. Brooks was making a couple of statements about how he was abiding by the rules and being respectful, things of that nature. I agree. He's done an excellent job while in court here this morning. He's been respectful of the rules. He made some early on. I let him, make his objections or lack of consent.
So she's praising him. This is what you do with toddlers. Oh, you were very good today. My gosh, you haven't spoken up once. You haven't interrupted me a single time. Wow, you're really doing great. Watch his reaction.
He did that respectfully. When I said I was moving on, he generally was able to do that. We were able to get through 2 witnesses. He was able to follow along, ask cogent, clear, responsive, and articulate objections. He was able to elicit information.
Again, she's laying this thing out to stop any kind of appeals based on him being incompetent.
Information from the witnesses regarding either their memory, their credibility, and other things. Generally speaking, he's been able to competently represent himself and provide, again, solid cross-examination this morning. So I'm going to give him an opportunity to hopefully settle back in and to come.
He's crying. I don't think anybody could have predicted that one. I don't know if he's crying because the COVID test came back negative. He supposedly was terrified of being COVID positive, although, yeah, right. But I think that her compliments of him is actually having an emotional take on him. He probably doesn't get complimented very much in his life, and for good reason. He's a real jackass, right? But I thought that this was just hilarious. But yeah, I'll see if I can find the clip of the COVID thing. It's a riot. Let's see what we've got here. I forgot about this part. He refuses to change out of his jail uniform. Yeah, okay. So he's a contrarian, just like a toddler, right? Whatever you want him to do, he is not going to do it, even to his own detriment. Obviously, you would want to wear a suit rather than the orange stuff, right? And he wants to do the orange because she wants him to be in a suit. If she could have said, quite frankly, I don't really think that you should be allowed to wear a suit. I have a firm belief that since you're in custody, you should wear the orange suit. He would be dressed up in Armani. That's what would be his reaction. So he's always going to oppose everything that he does, especially the prosecutor, who he hates. He's crying because nobody had ever given him a compliment before. I kind of wonder. I think that may be it. But again, the compliments are not because she really does think that he's doing a great job. She's just fending off any future appeals on this stuff. Oh, yeah. Reverse psychology works on this dude wonderfully. Well, let me give you an example. If you remember, somebody put in a Reddit post where they claimed that they were a juror and they felt that he wasn't getting a fair shake. So the prosecution gets a hold of this and says, "Look, I don't think there's anything to this." So what does Darrell Brooks do? He's got to oppose the prosecution. So he's saying, "No, this is serious. We gotta disband the jury." And I'm thinking, you idiot! You have somebody on the jury that might hang the jury. That's the only prayer you have, and you want to have the jury flushed for a new one? And all because the prosecution wanted it. And of course, the prosecution, they're just being like really nice about this, right? Um, so yeah, that's just typical Darrell. He is particularly stupid, I will say.
Here, but I just feel it important, given that you raised that issue, to put that on the record. I do want to address the case law that was filed by Mr. Brooks. I have a question, sir, because you had indicated there was this United States v. Lopez. I had looked up a case. I don't know if it's the one that you were referring to. I asked you if it was from 1995. You thought it was. Have you been able to look through your documents to tell me which United States versus Lopez you were referring?
I have not, but I also cited Higgins versus Levine as well, 415 U.S. 533, or I think you.
Okay, so here is where I would have handled this much differently. He cites a court case in his motion. This is about this subject matter jurisdiction. And he says here, well, I haven't had a chance to read it, look it over, as he calls it. I would have been all over him. Wait a minute. You cited a court case that you didn't even read? When is that ever acceptable? And post that back on him. When he cites court cases, and I think that judges should do this more often, because what do sovereign citizens do? They bring all these court cases. And I think, and a few judges have done it. By the way, I should mention, I'm going to have a video coming out where I'm going to examine the sovereign citizen judges and how they handle it. So it's going to be a whole library of these different judges like Ed Burke, Ed Tenney, Judge Dorow. There's been a bunch of them. Simpson, okay? But going back to what I was saying, I really think that these judges should put it back on these sovereign citizens. Here's a court case you cited. Tell me about that. Tell me about that case. And you know they can't tell you because they got this off a website. And all this is just a bunch of quotes and they just copy and paste in. And get on them. Wait a minute. You're citing court cases that you haven't read. You don't know anything about them. This one is a civil trial. Why did you bring a civil trial to me? What was your thought process? Because it was a bad one. Tell me about that. Put it back on them. Embarrass the shit out of them. And they'll quit doing this crap. Now they'll have to actually do some effort. They'll have to read the thing, right? And when they read it, they'll realize, okay, this probably isn't that pertinent. They'll still cite it. But yeah, this whole thing of just taking a whole bunch of court cases and copying and pasting them into a motion, the judges need to put an end to this kind of crap. And she doesn't do that here. I really wish she had. It's not out of the ordinary, though. Most judges don't do that, but she should have, in my opinion.
May have.
I was able to find Higgins versus Levine and Malo versus United States. I also found a case that is captioned United States versus Lopez at 514 U.S. 549. That's a case from, it was decided in 1995. It had to do with in part, with the
Jurisdiction.
No, it had to do with a provision in the federal statutes regarding the gun safe free zone and whether that was constitutional or not. It was a criminal case, but nonetheless, that was one of the major issues in that case. So I don't know if that's the case you were referring or not. And without a citation, it's hard for me to know. So that's why I'm asking you if you have any other information about that case.
I can possibly look on a break, but my understanding.
Yeah, he doesn't even know. He hasn't read it, and she should have got on him. After all, the judge is not expected to know these court cases by heart, so it's okay for them to not know what's going on. But if you are citing a case in your motion, you should read it and you should understand it. And if you don't, you should get called out on it. Remember, you're supposed to be acting as your own judge. On your own judge. That'd be great. The Sovsits actually believe that. But they think that they're acting as their own lawyer. They should act like a lawyer. Okay? Oh, by the way, just to keep a couple of questions here. There's a lot of Sovsit judges in Michigan for some reason. No, that's actually not true. The reason why you see so many Sovsit trials is because Michigan has laws about broadcasting these trials publicly. So you get a lot of, and for example, there's a few district courts up there that put out a lot of YouTube content. And Old Squishy Garden he goes through and read and watches those. So this is a basically example of cherry picking. It's selection bias. I don't think that there is any state in the union that has a lock on sovereign citizens, although a lot of them seem to come out of New Jersey. But again, that's just my impression. But sovereign citizens are all over the place. Chase Allen. I'm not familiar with the trial at all. I don't think I know anything about that one. Okay, let's continue on.
Of that particular case was dealing with the specifics of subject matter and personal jurisdiction, which is why it was brought up for the record, which is something that I have been doing adamantly, is asking for the court to provide verified proof of jurisdiction, which I have not been provided with as of yet.
Too bad. We don't have to provide you shit. Let's be clear. Whether or not you have to prove subject matter jurisdiction depends on what you define as prove. When it comes to jurisdiction issues, the bar is much lower than proof beyond reasonable doubt. Basically, it's a preponderance of evidence. The court is going to assume jurisdiction unless you can come up with a good argument that they don't have it. This is not like being accused of a crime where the presumption of innocence is on the accused. It doesn't work like that. So that's one problem with their argument, is that they don't understand what prove means. Prove just means convince, really. The other issue is that what was I going to say here about the subject matter jurisdiction? Oh, yeah. Prove to whom? And the Sovsits, they think that the judge has to prove to them that the judge has subject matter jurisdiction. Simply not true. The one you have to prove to is the judge. That's why they call him a judge. He judges whether or not the prosecution has provided enough evidence to show that the court has jurisdiction. In other words, that it's that judge's decision. And if the judge says, I have jurisdiction, game over. It's over. All they have to do is declare it. Now, you can appeal and maybe win by appeal, although with subject matter jurisdiction, those are extraordinarily rare. But you can appeal it. But if the judge declares jurisdiction, they have it. That's the way it is. I have never seen a sovereign citizen win this argument, and they never will, because they don't really understand it. And by the way, no amount of proof would satisfy Darrell Brooks. I mean, you could have the Pope and 7 bishops notarize a statement that the court has jurisdiction, and it would not satisfy him. Nothing will. He's just going to simply say, you haven't proven it to me. Okay? The Supreme Court could travel down to the court and show up and say the court has jurisdiction, and it won't be enough for him. Brooks and subject matter jurisdiction is like BLM and systemic racism. Always needs to be addressed, yet it will never be addressed to his satisfaction. Yeah, exactly. Okay, I assume that this is at Chase Allen. He was a soft-sit that was killed by police. You probably didn't hear about it because he was white. His mom was also a soft-sit. Okay, I am not familiar with that. But there was a case in Alabama, in Donnan, Alabama, where a soft-sit was basically shot dead by a female police officer who just pressed her gun in his stomach and fired. And of course, when you press the muzzle of a gun against the body, all the gases go into the body and it just basically destroyed his innards. It probably wasn't even a real powerful gun, but it doesn't take much if you don't allow the gases to leave. So they went into the body and he died, and his kids were there. His wife was there. They were screaming and hollering. It was horrible. I have a couple of videos on it on my channel. Donnan, Alabama. I forget his name, but it was just a terrible scene. And it was really caused by the female police officer unable to help the male apprehend him. Okay, let's see here. Oops, that didn't work. Okay.
Conversation?
With the district attorney's office.
Yes.
Did they ever inform you of who the plaintiff was in this matter?
Objection. Relevance.
Grounds.
Sustained.
Are you aware of any plaintiff in this matter?
Objection.
Grounds.
Relevance.
Grounds.
Sustained.
Have you ever talked to the plaintiff in this matter? Ever seen the plaintiff in this matter?
Objection.
Grounds.
Relevance.
Sustained under 90611. Mr. Brooks, you need to move on to a new topic or I will close the cross-exam.
I will move on. It has to be some type of ground stated other than relevancy or anything like that. The real ground should be put on record, Your Honor. We all deserve to know. The jury deserves to know.
Okay, a couple of things here. Number one, what the jury needs to know, I determine, not you. I'm the judge. I determine what the jury needs to hear. When did you become judge? Let me ask you, and I want an answer. When did you become judge? And just stare at him. You know, enough of this crap. The other one is this whole thing about grounds, and I realized it was kind of humorous. It was really humorous, but it was irritating as well. And like, I would have to, during one of the breaks when the jury's out of the room, ask him, what the hell are you doing? You yell grounds, they're going to tell you the reason why they're objecting. Why can't you just keep your mouth shut for just a few seconds and listen to them? I think that the judge could have really got on him about that. It was crazy. It was like, if I get grounds out fast enough, that means that I win. Right? It was crazy the way he was doing that. But I really think that she should have chewed his ass out for that. And she allowed that to happen way too much, in my opinion. KTZ, dang, I need to look into that case. I have thoughts on the competency of female cops and on soft-sits. I'm not sure my biases can handle it, huh? Yeah, it's one of my first videos that I came out with way back, way back, 3 years ago. But if you put in the search Johnny Walker Dredd sovereign citizen, you'll probably have it. If I get a chance here, I can probably look it up and post it in the chat. And the reason why I brought it up was there was a similar case involving a black male that everybody was rioting over, and it was in Atlanta where they burned the Wendy's down. And I was doing a side-by-side comparison and showing that the one with the white male sovereign citizen was worse, and nobody cared. And the fact is, I mean, KT said, you're not even aware of it. Why? Well, because the news Didn't do anything. And by the way, the cop was never even charged. But yeah, she claimed that he was trying to reach her taser, so she pulled her gun out and just stuck it into his stomach and pulled the trigger. And oh God, horrible, horrible event. Yeah, Rayshard Brooks was the one in Atlanta. I think it's Atlanta. Yeah, I'm pretty sure it's Atlanta. I was doing a side-by-side comparison of those two. Both involved grabbing a police's taser. In fact, Rayshard grabbed the taser and fired it at the police officer. So in my book, that was worse than what the sovereign citizen did. And quite frankly, you know what the original crime for the sovereign citizen was? That he refused to give his ID. He went to turn a dog into the dog pound, and they require an ID to do that. And he refused to do it. So the cop that was there, the female cop, called backup because he wasn't given his ID, and that's what started it all. Rayshard was drunk in his car in the drive-through where people couldn't get their food. So, yeah. Mm-hmm. Oh, really? Okay. I work not too far from that Winnie's. Do you live in Atlanta? This is an important question. If you live in Atlanta, I might like to talk to you. No, that's not that, guys. Everybody's like, oh, wow. What's Johnny doing here? No. It has to do with a guy by the name of Rashad Ritchie. Did you get my link earlier? Did you post it in the chat? Because I don't think I saw any links in here. Let me scroll up. Oh yeah, there is one. Oh wait, is that from? No, Graham. I don't see it up there. Post it again. I live outside of Atlanta. Okay. If shoot me an email sometime if you can at johnnywalkerdread@gmail.com. I'd like to talk to you. Yeah, I got that. Okay, let's go ahead and move on here. Yeah.
Brooks, appearances are as they were this morning. Do we have Ms. Gajewski available? All right, bring her in and we'll bring the jury in as soon as she's up here for her cross-exam.
State that I do consent to their name, nor do I know any individual by that name.
He did that throughout the entire trial. Keep in mind, he identified himself as Darrell Brooks earlier while he was arrested and early in the actual preliminary hearings. So if I was the judge, I would just ask him, wait, did you not identify yourself as Darrell Brooks earlier in the proceedings? And if he says no, well, let me pull out my ghetto blaster. You pull out his tape deck and you play it. Hey, this sounds like you. Did you just lie to me? I think that she could have shut this thing down. Now, in her defense, she doesn't think this is even worth worrying about. Whatever. So he annoyed us with this every time. But I still think it's funny.
Your lack of consent is noted for the record. All right, Ms. Gajewski, if you would please make your way back to the witness stand. And as soon as you are there, I will have the jury brought out. All right, go ahead.
On the record, before the jury comes out, I would like to direct Your Honor to a case United States versus Cotton 535.
Mr. Brooks, if you have a motion, you need to put it in writing, and then I will address it. I'm not going to deal with any oral motions right now. So if you're asking me to reconsider something, you need to follow the proper procedure.
What is the
proper procedure? What? You're waving that term in front of Darrell Brooks?
proper procedure, Your Honor?
I've told you
She can't tell you. That's what lawyers are for.
Repeatedly what a motion is. So and if it's a reconsideration, 806.07 is the statute I would direct your attention to.
It's not a reconsideration. It's just bringing up the subject matter jurisdiction again. Which
Sir, I've already dealt with this repeatedly. So any further times you want me to address it, you need to put it in writing for the court to consider a proper motion. with the relief that you're requesting, the legal basis, and the facts upon which you are relying.
So Darrell Brooks, I mean, the judge decides, look, I'm going to make him do it in writing. She thinks that's going to shut him down. It didn't work. I don't know if I had much to say about this one, though. I don't know why I put that one in there. So that's another one where, here we go. Here we go. This is the best one. Well, I don't know if there is a best one, but this is a pretty good one.
No running out of propane?
propane.
No running out for a fresh blue Rhino. Just you, a hot grill.
Right, the record to reflect that the individual known to this court as the defendant, Darrell Brooks, is present in court. He's in custody, but he is wearing street clothes. He's wearing a suit and tie and a mask. And good morning once again to everyone.
Also for the record, not identified by that name or consent to being called that name.
So noted. All right, Mr. Brooks, do you have a 13th subpoena? As we discussed yesterday, you wanted to call 13 witnesses. I told you had until this morning to fill out another subpoena and give it to the state so that they could review it.
Yes, I do.
All right, can you hand that to the bailiff, please? I'll just take a look at it quick.
While he is looking, I'll stop it. The GoSendMe for the Rittenhouse family, if you can spare a few bucks, they really need it. They're getting evicted this Friday, and they really have no place to go. If they can raise some money, they can get a new apartment. They set up a goal of $3,000. We've raised a half of it, $1,500. That's good. But they're still facing eviction. Well, they're going to get evicted, but they need money for the next place. And I already had a video where I invited Faith and Wendy on, and Mackenzie showed up as well for a brief moment. It's in my, it's like the last videos I published. So if you want to hear their plight, they were on my show. And if you can go in there and donate even $10, anything you can donate. And if you can donate 100, I will match up with 100 of my own. How's that? So anybody who can donate $100, I'll donate. If you can donate 50, I'll match it. I'll match up to $100. I've already donated some money before, but wifey poo getting kind of mad at me. So I have to be kind of careful about it, but I'm doing the best I can. All right. So let's go back to the scene here. And by the way, the URL for the link is in the description of this video. So if you can go there, try to help them out a little bit. It's really sad. They've had some really serious medical problems. And she's going like, what the hell?
Mr. Brooks, I'm reviewing this for completeness. And you have simply put on here, State of Wisconsin plaintiff. That's an entity. You have to name a person, sir. The date. Well, the date we would fill in. So I'll have it shown to the state, and they can let me know their position on that.
Any legal basis why that would not be accepted, Your Honor?
You have to have a person named, sir, so that they can come and testify.
By the way, I'm going to go step out and get me a drink and let this play because it takes a few minutes, okay? So I'll be right back.
Only have an entity named.
Is it not true that under the Sixth Amendment I have the right to face my accuser?
Mr. Brooks, let me hear from the state.
Yes, Your Honor, I agree with the court's assessment. The subpoena does not state a person. The subpoena form specifically indicates that the person requesting the subpoena is to indicate the witness's name and address. Mr. Brooks has simply written the word State of Wisconsin plaintiff for the witness name. The State of Wisconsin is an entity. It's not a person. The State of Wisconsin cannot testify at these proceedings, so the subpoena should be rejected, Your Honor. I object to that, Your Honor, on the grounds that every document that was filed in this matter stated that the State of Wisconsin was the plaintiff, which would lead me to believe that the state. How could they not be subpoenaed to testify if they're the plaintiff? And under the Sixth Amendment, I have the right to face my accuser. My accuser in this matter is the plaintiff, which is the State of Wisconsin.
Attorney Opper also brought up that it didn't have an address on there. None of my subpoenas had addresses, as we went on the record, and that was stated that a lot of the paperwork that I have don't have a lot of the people's addresses on there, and those subpoenas were accepted. So I don't see the difference with this subpoena not being accepted for the reasons that Attorney Opper just stated.
Let Party City inspire you to give the gift of balloons. P.S.
Mr.
Those little warnings that come up and say you're muted, I like those because I would have motored on for probably half an hour without realizing it. Yeah, got it. So he tries to call the state of Wisconsin to the stand. This is not exactly a common ploy, but I've seen it done before. And in my opinion, Judge Dorow and the prosecution handled this very badly. Let's watch some more.
Brooks, in relation to that subpoena, based upon my review for completeness, this court would note you have not named a person, you've named an entity, and the subpoena will be kept on file as part of the court record, but I'm not going to require the state of Wisconsin to testify in this case because they are an entity and you have not named a person.
Are they not? Or are they not the plaintiff, Your Honor?
They are the plaintiff in this case, sir.
And
I've always considered the plaintiff to be a civil court thing, but maybe in Wisconsin, in criminal trials, the state is considered a plaintiff.
why are they not able to testify, being that
Sir,
they...
you've named an entity, not a person. People are called to the witness stand to testify. You have had an opportunity to cross-examine every single person who has been called by the state to testify in this trial. I believe that your Sixth Amendment rights have been complied with.
Not if I'm not allowed to face my accuser, Your Honor. My accuser in this matter would be the state of Wisconsin. And with all due
Sir, I believe your Sixth Amendment rights in that regard have been complied with.
I'm requesting a written judicial finding of fact and conclusion of law on this issue for the grounds that I just stated. It was seen, based on the Sixth Amendment, that I'm not being awarded the chance to face my accuser, which I should be awarded that based on the Sixth Amendment. If I'm not able to face my accuser, then how can the claim even stand? How can a claim be brought against my client if I'm not able to face the accuser?
So this case is a criminal case in a court of competent jurisdiction in the state of Wisconsin, Waukesha County. This case was initiated initially by the filing of a criminal complaint. Then there was a preliminary hearing where probable cause was...
Yeah, blah, 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 blah. Hey, can somebody get me an update on the Oklahoma-Texas game? And by the way, I have a question for you. Can you spot the problem with his argument?
Found. After that point, there was an information that was filed. And at some point, an amended complaint, perhaps even a second amended complaint, was filed as well, putting you on notice of the charges and the factual basis for those charges, along with the statutes that are alleged to have been violated. I'm not going to explain any further why you can't call the state of Wisconsin in the way that you've subpoenaed them or attempted to subpoena them for the reasons I've already stated. I understand where you might disagree with the court's ruling, but my ruling stands, and I'm not requiring the plaintiff in this case to serve that subpoena in any way for the defects I've already noted.
May I state for the record?
And I'm also not going to issue a written decision on that. The record speaks for itself.
May I state for the record, Your Honor, that I have not even seen a complaint in this matter, and the jurisdiction still has yet to be proven, which is another thing that needs to be challenged. There has not been proven that there's subject matter jurisdiction as of yet. There's no verified proof of it. There's no verified proof of even a claim, especially if I'm not allowed to face my accuser. And I don't understand how you can make that judicial decision, Your Honor.
Remember, I'm asking you, what is the problem with his argument about facing his accusers?
When it's clear discrepancies in the paperwork of this matter. Like I said, I have yet to see jurisdiction be proven. It has not been proven. I have yet to see a complaint. I have not seen that.
The court has provided you with, I believe it was the second amended criminal complaint, along with the information that was provided to you previously and noted on the record. I've already addressed your motion to dismiss previously. I'm not going to revisit that. There's no legal basis requiring me to do that, sir. The plaintiff in this matter has presented witnesses to establish venue. And again, as I've noted previously, it's a criminal case with criminal charges, with a second amended criminal complaint detailing the factual basis upon which these charges are based. We're a notice pleading state. And along with the information, you have been made aware of all of the charges and the penalties you face and the factual basis upon which the state has brought these charges. We are in the middle of trial. Your objections are noted. We will continue today with the jury trial.
For the record, may I respectfully move for interlocutory declaratory appeal on this matter, Your Honor?
Your request is noted for the record. I'm not an appellate court, sir.
I would almost ask him, why are you asking me about an interlocutory appeal? Just post it back to him. Why are you asking me? That's an argument you make to the appeals court, not me. However, did anybody catch the mistake? Yeah, well, there's a logical problem with his deal, right? Once again, Mr. Brooks, you killed your accusers. Well, you can't say that, although we know it's true. They can't make it to court. That's not the problem. His argument is that the Sixth Amendment guarantees him the right to face his accusers. The Sixth Amendment doesn't say that at all. Let me read it to you. In all criminal prosecutions, and I'll just go ahead and share this tab here. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation. Informed of the nature, okay? That's all you have to do, is you have to inform them. To be confronted with the witnesses against him, not the accuser, the witnesses. Okay, let's go ahead and read a little bit more here. The right, this is the Sixth Amendment, and this is findlaw.com, which is pretty reliable. The right to confront witnesses brought against them. I cannot understand why in the hell a judge and prosecution, by the way, they missed it too. Why didn't you catch the fact that he's misquoting the Sixth Amendment? Oh, I don't know. Let's see what we got here. We got some HTML. No? Oh, 7. Yeah. Okay. It includes statement with 7-3. Is that a final score? I have to be careful about jinxing my own team. By the way, I'm very superstitious when it comes to sports. It's kind of odd coming from somebody with a background in electrical engineering and physics to be superstitious like that, but I am really superstitious to the point where I will not even watch games because I'm afraid I will jinx my team. That's pretty sad. Oh, is it C? Yeah, they include. Okay, got it. Yeah, the main, got it. I used to program in C all the time, and I was one of the few that was doing Objective-C because I had a Next computer. So I was doing a lot of objective programming pretty well before a lot of people did. But I haven't programmed in C or Fortran or anything like that in a very long time. I did a lot of Java FX coding as well. And you probably have never heard of Java FX. That one didn't last long. Okay, let's get back to what we were doing. So I know computing. Everybody's now looking to see what Java FX is all about. I also programmed in Mach, which was a Unix variant. All right.
Brooks appearances.
I chose Wix for my business because of its massive scope for functionality and...
Go away.
Are as they were this morning. Do we have Ms. Gajewski available? All right, bring her in and we'll bring the jury in as soon as she's up here for her cross-exam.
Wait, did we see this one already?
Consent to their name, nor do I know.
I think we saw that one
by their
already.
name.
Sorry.
Your lack of consent is noted for the record. All right, Ms.
I'm going to move forward here.
Are you aware that?
So, yeah, getting back just as a quick statement, you do not have the right to face your accusers. You have the right to face anybody bearing witness against you. Okay? And so if you kill somebody, those who are going to be taking a stand, you have a right to cross-examine. And essentially, the Sixth Amendment says that you have the right to cross-examine anybody that the prosecution puts on the stand. Okay? That's basically what it means. And nobody in that courtroom got that.
To the best of your knowledge, are you aware that for a case, there has to be an injured party?
Objection.
Grounds.
Sustained.
As you said, the state of Wisconsin called you to testify. Did they at any time identify themselves as an injured party in this matter?
Objection.
Grounds.
Argumentative. Irrelevant.
Grounds.
Sustained.
I think this one was my concern about is using the word grounds all the time. So I'm going to skip this one. I've already talked about it. And I have a little note to myself, provide a special hearing at the end of testimony. Okay, so here's something that maybe the judge could have done. He's always bringing up this subject matter jurisdiction. He's always bringing up the facing the accuser, all those things. I'm wondering if the judge couldn't have told him, hey, say, look, when we get done with the evidentiary part, I'm going to provide you a good 2 hours. Well, okay, maybe an hour of time to present these arguments to me. And I promise that I will respond to them. Now, keep in mind, you raise these questions up during the trial and we can forget all that. I'm providing the special hearing for you at the end of the trial. And therefore, all these questions about, your name, the fact that you don't want to be Darrell Brooks, the subject matter jurisdiction, the nature and cause, all that kind of stuff, hold on to that. And by the way, this will give you plenty of time to research and to strengthen your argument. However, you bring this thing up during the trial, you can forget it. We're not going to do it. And that might have, you could even then stop him. I like to talk about the subject matters. Hey, I thought that we had told you already that you're going to have this hearing at the end. So why are you bringing that up? Okay. I think that the judge could have done that. And it might have been very effective. Then again, I'm not sure anything would have been effective against Darrell Brooks. And by the way, I did invite Faith and Mackenzie and Wendy to come on tonight. They're getting off work late, so I don't know if they're going to be able to make it. But I did offer them the opportunity to come on and explain their situation. And of course, I also have live streams that I've already performed. So if you want to hear about the situation they're facing, you can go to my channel and look up the last few videos that I've done.
To the best of your knowledge, being in law enforcement for as long as you have,
would it be fair to say that an entity, which is not a human being, living person, can bring a claim against anyone?
I believe they.
Object, Your Honor, to the
Grounds.
relevance.
Grounds.
Hold on, let her get her objection out, okay?
I mean, I've tried to be patient, but these questions really have no bearing on this.
The objection is sustained on relevance grounds. Next question.
That we've tried to be patient is a signal to the judge. Judge, you're letting this go on too long. Enough. Shut him down on this kind of stuff. But the judge, in my opinion, doesn't do a very good job of that at times. I don't know if I had much else on that, so let's go on to the next one. Because we've been going at it for a while now, and I'm getting a little bit tired. I've never heard of fractran. I have no idea what that is. But at one time, I was a pretty damn good Fortran programmer. In fact, I was doing a lot of testing of routines for IEEE and sending them back comments about how the numerical analysis of their routines was off because I was doing quadruple precision coding. And so if you're not aware of this, double precision was the best that Fortran could do in hardware. I was doing quadruple in software and finding mistakes in their subroutines. So I was communicating back and forth with IEEE on that. So I was doing a lot of heavy duty Fortran at one time, but that was 20 years ago. I don't know what fractran is. Oh, here we go. What grounds does Darrell Brooks have to constantly whine about consent when he impregnated a 15-year-old? Yeah, that's a little hypocritical of him, isn't it? And this notion that somehow, well, you can't sentence me because I don't consent to it. That's a very sovereign citizen thing. And it's sovereign citizenry at its most ludicrous.
Have you ever had any interaction with the plaintiff in this matter?
Objection, irrelevant.
Grounds.
Sustained.
How long have you known the plaintiff in this matter?
Objection.
Grounds.
Let her get her objection out, Mr. Brooks. It's sustained on relevance grounds.
Well, I do respect, Your Honor. I think that those are valid questions to the matter.
Mr. Brooks, they've been sustained. Next question.
Again, I think this is one where I was pointing out that I don't care what you think. I determine what's relevant and what's not. Okay, let's move on to the next one. Sorry, I did kind of compile this at the very last moment, so it might not be all pertinent.
So you've never received a letter from someone writing someone in jail? No one is going to... When you
You're
say
not
to
answering
me,
my
when you
question,
say to
sir.
me,
What's the basis why you believe they're from Miss...
Did you see him eye roll? This is great. Watch.
when you
You're
say
not
to
answering
me,
my
when you
question,
say to
sir.
me,
What's the basis why you believe they're from Miss Patterson? Is there some information in them that only she would know? Did she sign the letters? Is it penmanship that you recognize? Why do you believe they're from her as opposed to somebody else sending you information? Could be your mom, could be, I'm just saying, could be anybody else. You got to answer my question. It's called an offer of proof.
But you still got to understand why this is mind-boggling to me. Like, how I got a child with this woman. Why would I not know her handwriting?
But you have to have a foundation for these letters, sir. That might be through your own testimony. So that I'm trying to figure out why you believe they're from her. Not.
I would be tempted to say, why should I trust you? But this is a case where I think she handles this pretty well.
All this other stuff about I'm in jail and I have a child. I'm trying to I need to know. It's called an offer of proof.
Are you serious?
What do you believe? Why do you believe they're from her? I am serious.
Because they're from her.
But you're assuming.
Like, how else am I supposed to answer that?
That's not my problem. You're the one that has to come up with the answers. I'm not going to come up with them for you. The fact that you can't, that's not my problem. And the NMP, not my problem, is something that she could have used a lot more. Like, you don't understand the procedure? Not my problem. You know, she could have used that a lot, I think, but she's very nice and patient, I must admit.
I've given you a few reasons why it would lend to that opinion.
So it has to be put in a legal term.
The bottom
or
line is I
something?
need the letter. So
It has to be put in legal terms because this is a courtroom.
you're going to question her on that. The state absolutely has a right to see the letter. So you need to provide that letter. The bottom line is I'm not going to allow any questioning without having that letter. So the state has the ability to question you about that, or question this witness, and to look at the veracity of what your claims are here. So I may take an early lunch. If that's in your cell, then you can go get it and bring it. But without that letter, I'm not allowing this line of questioning.
I'd be tempted to say, Mr. Brooks, do you have a problem with the ceiling? Is there an issue here? Because you keep staring at the ceiling. Is there a problem? And just kind of put it on him. But then again, I don't know. You don't want to be too hostile.
Do you have the letter with you in court?
I just said no. How many times I got to say the same thing on record?
You know, sometimes, sir, I don't hear what you say because you interrupt me so much or you answer quietly. And I'm taking notes and I'm focused on probably a dozen things at the same time.
But if I say something under my breath, everybody seems to hear it. Everybody seems to hear that just fine.
In a quiet courtroom, yes, we can hear it very clearly.
Everybody assumes that it has to be disparaging.
Once again, you're doing this tactic.
Because
it's
not a tactic, it's facts.
We're talking
it's
about
facts.
To some other.
Okay, remember what I said earlier about the toddler mom thing? This is what's happening here. She's getting dragged into the mud pit with the pig. And this is where he thrives. And she's reacting to it. In my opinion, she's not handling this part of it very well. I do, the very fact that she's going to put the nails down here pretty soon is pretty good. But you can't allow the defendant to just do this. I mean, you're reacting to what he's doing. Watch.
It's facts, because I find it hard to believe that
I'm gonna
all
let
of a sudden nobody hears what I say.
I'm going to let the state make a record of why they believe it's objectionable, because I haven't let them do that. I've given you multiple opportunities to tell me why you believe it's...
I didn't get these pictures from nobody else. Why was somebody else...
The record will reflect you have 2 pictures that you believe were from this witness.
That I know is from...
No, that you believe.
That I know.
All right, I'll ask the state their position on all of this.
My position, Your Honor, is that these pictures, first of all, should not be admissible. 1, because of a discovery violation. We've never seen them before. 2, because we have reason to believe that he did not get them from Erica Patterson. He is on a jail phone call talking to his mother, Dawn Woods, about Dawn Woods sending these photographs to him. No.
That's a lie. I object to
Let
that.
the state make their argument without interruption, sir.
That's a lie, though.
I think a warning about being sent to the other room was in order here. Okay. But the good part's coming.
3, I believe that these photographs are designed to make a suggestion to the jury that Erica Patterson is a bad mom. I think that is what the defendant is trying to do. And if we're going to go down that road, then we would be forced to counter that claim. First of all, it doesn't make her an incredible witness, if it's even true. And second of all, if we go down that road, we would be forced to counter that claim by pointing out that not only does the defendant not live with the child in question, he doesn't live with any of the other children that he has. He impregnated Erica Patterson when she was a minor in Nevada, and for doing so, he was...
By the way, 3 different children from 3 different mothers. Gee, I wonder what the problem is in our modern society. There are 3 kids out there who don't have a father. Well, they do, but he's in prison for 1,000 years. I think it was I Am J9 Eve. By the way, I Am J9 Eve is one of the funniest YouTubers on the Darrell Brooks case. And she said that you better hope that your cellmate is Dracula if you're ever going to see the light of day again. And I thought that was so funny. I'm going to have to type that in. I Am J9 Eve. Hilarious. And by the way, she's doing the whole Tiffany Henyard thing too. I'm going to type that in here. I Am J9 Eve. Go to YouTube, subscribe to her. She's got great content. I actually binge watch her at night because her videos are about 20 minutes long. So when I'm going to sleep, I put it on and she cracks me up. Yeah, we're about to open some doors. Here we go.
convicted of statutory sexual seduction, pled guilty in March of 2007 to that felony offense, and is a sex offender on the registry as a result. So if there's any causation that would lead to Erica Patterson being a bad mom, Mr. Brooks has a direct role in that causation.
And that's
Furthermore,
I'll object to that.
I'm not
because
done.
that's a lie.
Let him
Because at the end of the
finish.
day,
Let
if
him
we,
finish,
if we gonna open the door
Mr.
on that. No,
Brooks.
since he want to make a record and not be accurate, so let's be accurate all on the record since you think you know so much.
Once
So
again,
we can
Mr.
open the
Brooks
door
is
on
being
we can open the door
loud,
on how old she told me she
disrespectful,
was when we met.
interrupting.
We can ask that question
He is
too then.
over the
Did you
top,
ask that?
animated
Do you
right
know
now.
that?
Mr. Brooks, I'm ordering you to sit down and to let the
No,
state
that's
finish.
not. I'm not going to sit here and let somebody be inaccurate on the record and lie on the record.
Right. Under Illinois versus Allen, I've warned him repeatedly. He's being removed from the courtroom. And you know what? Let me dial that back. We're just going to take an early lunch, 1 hour. We'll be back. And unless he brings that letter, then he can show it is inadmissible. She will not be questioned. And under 906.11, I will declare the cross-examination closed. Thank you. We're in recess. 1 hour.
Okay, what do you think? There's a few things that she did here. She threatened to put him in the other room, and then decided, no, let's not do that. I don't know. I mean, that kind of sends the message to him that he can act like this and get away with it. But then again, she's putting together what I would call restraint. He's acted up, and she has decided, since they're taking a break anyway, why put him in the other room? Let's just take a break here, and then we'll let him back in. She is really bending over backwards to allow him to provide as fair a trial as she can. I don't know. What do you guys think? I mean, what would you have done here? I mean, send him off to the penalty box? I think I would have. By the way, Darrell Brooks was pissed off because Erica Patterson told him, according to Darrell, that she was 18, but she was only 15. And that somehow exonerates him. No. These are the kind of crimes where it doesn't matter about intent. It just is. And you did impregnate a 15-year-old. It doesn't matter whether you thought that she was 18 or not. It makes no difference. She was 15. And the fact that you did not confirm that she was an adult is on you. I don't know if she produces a fake ID, what that would do. I mean, there's probably a lot of case law on that. Don't know. Luckily, I've never had to worry about that too much. I typically don't go cruising for young girls. She barely looked 18 during the trial. She looked in her early 20s, I'll admit. And keep in mind, she's like 32 years old in the trial, but so she must have really looked young. Those kids didn't have a father before he went to prison. Yeah, that's true. Honestly, they're probably better off now. Yeah, having Darrell Brooks as your father would be really problematic. I really hated the part where he talked about wanting to kiss his kids. And I'm like, oh, God, I can't imagine being kissed by Darrell Brooks. I mean, if that happened to you and you turned out to be a bad apple, I would understand. Okay, I think I have one more here. And it's almost 10 o'clock, which is about right. Oh, do I have an update on the Oklahoma-Texas game?
I'm going to ask you if you are ready to answer my questions from previously and also to let me know whether you are asking to stay in that courtroom.
The old pretend that I can't hear you trick. He's like a toddler.
I've been advised he can hear and see. Mr. Brooks, we are on the record. I'll go through the topics one by one. You are in the other courtroom. You are invited back here. Would you like to come back here? Yes or no? The audio is on. Would you like to come back to this courtroom, sir?
You're unmuted.
So I'm finally unmuted.
You've been unmuted for a while, since I came back on. My understanding, sir, is you'd like to be in that other courtroom. Is that true?
He can hear her. She can hear him, but he's got to put the headphones on. Delay tactic. Oh, wait, I got to look at this. 8-3. Which inning? That's kind of important. Okay, but that's good news. Wait, what's this? I would send a paste bin, but Susan won't let me post links. I don't know what you're talking about, Graham. You're killing me tonight. That's right. He did plead guilty.
Record to reflect, he's putting on the headphones.
What's going on?
Mr. Brooks, I'm inviting you back to the courtroom. My understanding from a relay of information from the bailiffs is that you don't want to come back here.
I ain't saying nothing.
All right, are you ready to come back then?
Not if I'm just gonna get held in contempt again.
I did
Again, he's going to avoid answering yes or no to any question.
hold you in contempt
Then why am I even over here?
so that I could make a ruling and make a record without an interruption.
He raises the whole contempt thing. Again, he wants to be held in contempt so that he gets an additional hearing and a little delay in the proceedings.
Pursuant to my authority in Illinois versus Allen.
So did you make your record?
I did.
Am I ever gonna get a chance to make the record without being interrupted?
Mr. Brooks, I'm asking you, the first question is, do you want to come back into this courtroom?
Not if you're gonna hold me in contempt.
Sir, I need to continue with the trial. So if you don't answer yes or no, then I will presume you want to be in that courtroom, and you'll, by your conduct, waive your right to be in this courtroom.
By what conduct? I didn't consent to
By
being held.
failing to answer my question, sir. So I'll ask you again.
Are you gonna hold me in contempt? I don't want to be held in contempt.
I will ask you again, sir. Would you like to come back to this courtroom?
I'm supposed to be in there anyway.
So twice now I've asked him. He has not answered a yes or no. Mr. Brooks, I'll ask you a third.
I think that Judge Dorow actually miscounts the number of times she's asked more than twice.
Third time. Would you like to come back into this courtroom?
Yes, if you're not gonna hold me in contempt.
Given his yes, I will close the courtroom. He'll be brought over, and then we'll continue when he comes into this courtroom. Thank you.
And for the record, I do not consent to being called that name.
And this goes back to my claim earlier that she should just tell him where to be. If she wants him back in the courtroom, that's where you're going to be. And if you act up, I'm going to send you back to the old, penalty box. And by the way, I've had a bunch of this, so I'm a little bit loopy. I'm not Nick Rikita level, okay? But, this stuff is starting to wear on me a little bit. So we've been going at it for just about 2 hours, and that was the last one I had. Let me see if there's one last comment here I had. Okay. So asking him, do you want to come back? I'm not in favor of that. Tell him where to be. Order him around. He's in custody, and you run the courtroom, not him. But at any rate, my Sooners were victorious tonight. Yes. And that's good news. Hopefully they can win one of the next two and win the national title. That'd be wonderful. And you know what? Wendy or Mackenzie or Faith were not able to make it in tonight. I think they're just tired. They came in late. They worked all day. And so if you can, before you leave, before you go to bed tonight, can you stop by and slip them a few bucks? $10, $20, anything you can spare would be greatly appreciated. and I'll match it. So if you put 50 in, I'll put in 50. You put 100 in, I'll put in 100. I can't match it one for one if it gets a lot of money, though. Okay, there's a limit to that. All right. But I'll post in there because I want to do my fair share. And I've already contributed. They are really nice people. It's a great family. And for those of you who are all upset about Kyle, none of them had anything to do with Kyle shooting anybody in Kenosha. Okay. Wendy did not drive Kyle to the protest. In fact, she texted Kyle and told him not to go to the protest. He did anyway. All right. I don't have an issue with him going to the protest, by the way. But I do have an issue with people who claim that she dropped him off there. Didn't happen. He drove himself the day before. Okay. She had nothing to do with that. She had nothing to do with his rifle. He bought the rifle in Wisconsin with his friend Dominic Black. Dominic Black actually bought the rifle. And the rifle was stored in Wisconsin. She had nothing to do with it. She doesn't allow guns in her home. And she was very upset with Kyle for getting the gun. So what did she do to earn all of this vitriol? Nothing. This is a great American family who has struggled. They've always been poor. Even, 10 years back, she's always struggled to keep a roof over her head, but she does work hard. She manages to make it. But medical problems have come up with Faith recently. She talks about it in my live stream. And that has put them behind the 8 ball when it comes to paying their rent. They got evicted. They need money to get their next apartment. However, Faith, Mackenzie, and Wendy are now working. They work for a living. They're not sponging off the government. Faith didn't take out any student loans to go to college. She was in college. I helped her with her homework, so I know she was in college. But she didn't get any student loans for that. She paid for it out of her own pocket. They don't believe in sponging off the government, but they're in desperate straits right now and they need help. So if you can go on there, hey, thanks for sending me the email, KTZ. I'll fill you in, but go on, click on the link, leave a few bucks if you can. And if you can't, I fully understand, but you can still spread the word. Go on social media and tell people about the fundraiser. That alone can actually help more than donating sometimes if the right person watches it, reads it, and jumps in. So let's do it. They have to raise the money by Friday. So I'm really working hard. They put $3,000 down as their goal. We've reached $1,500. That's good, but they need more. So any final comments, post them in the chat. Like I say, this took a lot longer to put together than I thought. And I would love to have put together a few more clips in there that I couldn't find because I just didn't have the time. So I did my best. So in the future, I'm going to put together a list of sovereign citizen judges: Ed Burke, Ed Tenney, Judge Hurley from Florida. You got Simpson. I forget the name of the judge in Michigan with the ponytail, kind of the gray-haired dude with the ponytail. He encounters a ton of them. They all have their own unique way of handling sovereign citizens. So I thought that would be a really cool video to do a comparison. And by the way, if you think that Simpson is tough on sovereign citizens, you haven't met Edward Burke out of New Hampshire. The whole free Keene deal. He's the one that puts all of these sovereign citizens in jail. And the one guy wore a cap inside his courtroom, refused to take it off, and he got like 2 weeks. So Ed Burke is the sovereign citizen slayer, and I'm going to do a whole video on just comparing everybody's different styles and stuff. Judge Middleton, yeah, out of Michigan. There's a whole bunch of them. There's Webster out of Kansas. She's pretty good. And there's one out of Detroit, a black judge with a shaved head. He's always kind of sitting back and leaning behind this plexiglass. I forget his name, but he handles a lot of these cases as well. And he's very inconsistent. I find that sometimes he's very tough, and sometimes I wonder, geez, man, you're getting rolled, but whatever. I'm very interested in the Sovsit judge topics. Well, I'm going to post this thing out. I've been watching these, and by the way, the in my opinion, the best judge against these guys is Ed Tenney, and you'll see why when I do the actual the video. I really like him. At any rate, I'm tired, guys. Thanks so much for Judge Manning. Is it? Oh yeah, Manning out of. Is that the one out of Detroit? I think that's the one out of Detroit. But anyway, thanks everybody. I appreciate it, but I'm tired. I think we're going to have to get off the air now and go on. See if you can help the Rittenhouses out a little bit. And no, the money doesn't go to Kyle. Kyle is not speaking to his family. And in fact, Kyle didn't even contact Faith when she went into the hospital. So there's some real bad things going on, bad juju. Okay, so any money that goes to the Rittenhouses, it's not going to go to Kyle. That's a separate deal, and hopefully you can help them out. Have a phenomenal night, everyone. KTZ says absolutely. I've dabbled in Sovsits and First Amendment auditors. Oh, okay. I was going to do an actual video on comparing Sovsits and First Amendment auditors because they're not the same. They have completely different personas. Yeah, Judge Manning. I've heard Judge Manning, but I can't put the name to the face. But good night, everybody. I appreciate you joining in. And again, go out there and help the Rittenhouses if you can. Good night.